This morning is the case entitled State of Vermont v. Travis Smith, case number 23 AP 317. Representing the appellant, Travis Smith, is Rebecca Turner. Representing the appellee, the state of Vermont, is Dana Nevins.
Thank you very much, and good morning, everybody. We'll hear from counsel for the appellant. Please introduce yourself, identify your client, and then proceed.
Good morning, Your Honors. This is Rebecca Turner, representing appellant Travis Smith this morning. The Vermont Constitution mandates, on its face in plain language, that the punishments shall be in proportion to the offenses. Contrary to this directive, Mr. Smith was punished as a sex offender felon for having committed merely misdemeanor conduct. And that is inconsistent with Section 39 and therefore warrants this court's error correction in this extraordinary case, which is before the court on plain error grounds. Now, the state claims that this does not rise to the level of plain error because the law is not plain. However, there could not be any more plain law than the Vermont Constitution itself, nor could it be more plain on the face of the plain language itself. Again, in affirmative, mandatory, no exceptions language, punishments must be in proportion to the offenses. Now, the state claims that the prosecution has expansive authority, and indeed it does, as does the legislature in enacting and choosing the crimes that shall be established in the state, and as does the judge in imposing a sentence. But none of these branches are above the Vermont's Constitution itself, and that is what is at stake.
What the question I would have really is that there was a charge that had a felony, and there was a lesser included with a misdemeanor, and the jury convicted on the felony. And so, is it the charge itself, or is it the imposition of the sentence as part of the conviction that the jury found?
The proportionality constitutional problem doesn't occur until there is actually a sentence imposed, but it is because of the felony that was charged in lieu of the misdemeanor of conviction. Now, the argument here isn't that on its face, felony LNL is always going to be inconsistent with Section 39. No, it's here as applied to the facts as chosen by the prosecution in its insertion of what were the criminal acts here that makes this directly inconsistent with the Constitution. And so it requires this court to look at the jury instructions as charged, and specifically the prosecution's theory of its case. How do we know that it asserted that lewdness and the lascivious behavior constitute one and the same act? How do we know? Because the charging instructions permitted the jurors to find either one of those elements based on one of the three proposed asserted acts. And we know because the prosecution argued to the juries in its closing argument that any one of those qualified as both lewdness and lasciviousness. Now, this court has clarified in previous litigation that the only difference between the felony and the misdemeanor lewd and lascivious behavior and the lewd misdemeanor prohibited acts, the only difference is the lascivious behavior component. Now, this court has clarified that there is a different meaning attached, meaning determined not based on a heightened mens rea, not based on a heightened level of bodily injury, but a meaning that is associated and attached based on community norms, morality assessments. Whatever the meaning of lascivious behavior, it has escaped constitutional due process challenges. But on a proportionality analysis, looking at the offense itself, we look at what the actual crime asserted. How can it be that in this instance, Mr. Smith, who was merely charged with the same single act constituting both lewdness and lascivious, is now subject to
Has 1 minute remaining.
Sex offender registry requirements, a 5-year term of probation, greater incarceration, when the same act is assessed to have been reasonably punishable without the sex offender registry requirements at a misdemeanor level, lower imprisonment and probationary terms. Now, this is, again, the extraordinary case where the Law is plain. This court has issued a decision analyzing, providing us the controlling analytical framework that the state ignores completely, asserts that there's no governing authority, but this court should look at State v. Burlington Drug Company. It provides the analysis. And in my reply, I go through how that is controlling here. The error is substantial for Mr. Smith. Mr. Smith has spent nearly his entire life without charge before this one. This was his first charge and conviction. 50 years old, a military veteran, former law enforcement, 20 years service, working for the Brattleboro Retreat. He has shown his entire professional life towards public service. He gets convicted of this charge, and now the punishment is substantially different from what the misdemeanor level is. On a personal level, he's a single parent trying to raise his daughter. And while there are certainly other procedural routes, this is the case where the appellate court here can exercise its extraordinary authority, look down here and make this error correction to correct this injustice now.
All right. Your time has expired, counsel. Thank you very much. We hear from counsel for the appellee. Please introduce yourself, identify your client, and then proceed.
Hey, please the court. My name is Dana Nevins. I represent the state of Vermont in this matter.
Thank you.
Appellant's argument that the lewd and lascivious conduct is invalid under the Vermont Constitution has a number of issues. First, given that we're on a plain error review, the courts recognized in both Schmidt and Nash that a constitutional issue of first impression as a logical matter does not rise to the level of obvious error necessary to satisfy plain error.
Mr. Nevins, a constitutional error clearly would be under the point error, would it not?
I'm sorry,
A constitutional issue as raised by the defendant or the appellant here would rise to a level. I mean, the analysis under that could be under point error, could it not?
It could, but under both Schmidt and Nash, they recognize that a issue of first impression that the trial court has no guidance on cannot be obvious to it that there would be a proportionality issue if there is one, because it has never come up before. So it could not rise to the level of an obvious error to satisfy the plain error standard. But
Is this a conviction issue or is this a sentencing issue?
I'm
Go
sorry.
ahead. No, go ahead.
I don't think that it is if it's an issue, it has to be a conviction issue, because the conviction occurs, and I think the proportionality analysis requires not necessarily what the sentence actually is, but what the potential sentence could be. So I think it would be, if there is an issue, it would be a conviction issue. But there's also this argument that the 2601 and 2601A prohibit the same behavior, which was an idea that the court rejected in re AP, that there are different definitions for lewdness and lascivious. The fact that a single act can be both lewd and lascivious doesn't change that. That was actually the facts of in re AP, which was an unconsented touching of another person's breast. So just the fact that there is a single act that can be both lewd and lascivious is of no moment. And the states or the courts holding in State v. Trowell 200 VT 365 also supports that proposition, which was not cited in my brief, but also supports that a single act can satisfy two different elements of an offense. So the fact that one act was both lewd and lascivious is of no concern. He satisfied the felony level behavior. And there's also the potential sentence here was not disproportionate to the severity of the offense. under the test articulated in Solemn v. Helm, and used by this court in State v. Venman. The harm to the victim in this case was substantial. She gave a victim impact statement talking about how the behavior truly tore apart her life. And the penalty for lewd and lascivious conduct is in line with other sex offenses in Vermont and comparable statutes in
You
Massachusetts.
have 1 minute, counsel. You have 1 minute.
Thank you. So I think it fails for all of those reasons. And unless the court has other questions, I would rest on my brief.
Okay, thank you. Does the appellant have time?
Appellant has no time remaining.
All right, please call it.